Oh, he's in. Court does call the case, People versus Carlos Strong.
People.
Assistant Public Defender Natalie Pate with and on behalf of Mr. Strong, who appears via Zoom from the Macomb County Jail. Sir, could you please state your name for the record?
Carlos Jaquan Strong Jr.
Thank you, Your Honor. There is a resolution in this matter to which Mr. Strong will be pleading no contest to the added count retail fraud in the third degree. And in exchange, the original count one of retail fraud in the second degree would be dismissed.
That's correct, Your Honor. He'll be pleading to a 93-day misdemeanor with a $500 fine or treble amount, contrary to MCL 750-3560 as Doc 4.
Hey.
Yeah.
I got a question.
What? Okay, what's your question?
Is it possible I can take a plea without the $500 fines?
Mr. Strong, that is just the max amount of what can be sentenced. You will not be being sentenced today. But it will be up to the court like we discussed.
Oh, dang. Another one. Dang. Fuck, this the third one.
You want to raise your right hand? Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
State your name again.
Carlos Strong.
Sir, it is this court's understanding that you're going to be pleading no contest to the charge of retail fraud third degree. That is a misdemeanor, punishable by up to 93 days in jail, $500 fine plus court costs. Fine could be increased at 3 times the value of the property taken. If that's greater than $500, that would become the maximum fine. You understand that?
Yes.
Okay. Do you understand what a no contest plea is?
Right away, you can already feel this hearing slowing down in a way judges absolutely do not enjoy. Carlos Strong isn't just saying yes and moving on. He's stopping the process to actually ask what the plea means. And honestly, that changes the entire energy of the courtroom. Because now Judge Simpson has to carefully explain the difference between a guilty plea and a no contest plea on the record, step by step, making sure there's zero confusion later. And this matters more than people realize. A no contest plea may sound softer than guilty, but in sentencing, the court can still treat it almost exactly the same. That's the part defendants sometimes don't fully grasp until it's too late. What's fascinating here is that Strong immediately focused on the money first, asking about the $500 fine before anything else. That tells you where his head is financially and emotionally. Meanwhile, the court is trying to lock down procedural clarity because if this plea falls apart later, everything becomes messy. Judge Simpson stays patient, but you can already sense he's preparing for a complicated interaction. And viewers, pay attention. This is one of those hearings where confusion, probation status, and multiple overlapping cases are about to collide fast. This starts as a simple retail fraud plea, but it definitely doesn't stay simple for long.
Could you explain to me the difference between no contest and guilty?
Say that again.
Could you explain to me the difference between a no contest plea and a guilty plea?
All right. A guilty plea, you would be admitting all of the elements of the charges. In this case, what would happen in a no contest plea is you wouldn't be saying anything about the charges, but basically giving the court permission to review the police report or other factual information to determine whether or not a crime took place. You understand that?
Yes.
Okay. And it also means that you're not contesting or disputing this charge. You understand that?
Yes.
Yeah. Okay.
You understand also that for purposes of sentencing, the court would treat you the same as though you had pled guilty to the offense. You understand that?
Come again.
You understand that the court will treat you the same for purposes of sentencing, the same way as though you had pled guilty to the charge.
Yes.
Okay. Ms. Pate, the basis for the no contest plea?
Potential civil liability, Your Honor.
All right. So, sir, do you still wish to plead no contest to this charge?
Yes, sir.
All right. And so to the charge of retail fraud third degree, how do you plead?
No contest.
All right. Now you understand that by pleading no contest, you will not have a trial of any kind.
I understand.
All right. Because of that, you're giving up certain rights. You're giving up your right to call witnesses to speak for you at trial or to have this court compel their attendance. You're giving up your right to see, hear, and question all witnesses against you at trial. You're also giving up your right to be a witness for yourself or to remain silent, not have that silence used against you. And you're giving up your right to be presumed innocent until proven guilty beyond a reasonable doubt. You understand that?
Yes.
This is one of the most important moments in any plea hearing, and a lot of viewers underestimate just how serious this section really is. Judge Simpson is now running through the constitutional rights checklist, and it may sound repetitive, but every single word matters legally. Once Strong enters this plea, there's no trial, no witnesses, no jury deciding guilt, no confrontation rights. Done. Finished. That's why judges speak slowly and deliberately during this phase. They're building a record that protects the plea from being challenged later. But notice something else happening underneath the surface here. Strong repeatedly asks for clarification throughout this hearing. Come again. What's the difference? Could you explain that? Those aren't minor interruptions. They signal somebody who may not fully process legal terminology in real time. And courts have to be extremely careful with that because a plea must be knowing and voluntary. Judge Simpson knows that. So even while moving efficiently, he keeps circling back to make sure Strong verbally confirms understanding. And let's be honest, this is where courtroom reality hits hard. Retail fraud might sound like a smaller offense compared to felony headlines people usually watch online, but these misdemeanor pleas still carry serious consequences, especially when probation is already involved. One bad decision starts stacking on top of old decisions, and suddenly a simple plea hearing turns into a chain reaction affecting multiple courts at once.
You understand you're giving up your right to appeal of right.
Yes.
Are you on probation or parole?
On probation for the 24th District Court.
All right. Were you on probation at the time of in June 26, 2022?
Yes.
All right. Were you on probation to them?
Yeah. Yeah. What
Okay.
charge is this for?
What?
Is this for Ann Arbor? Pittsfield or Eastern Michigan University?
If I may, Your Honor, I do believe Mr. Strong was on probation at the time of this offense.
Oh, thank you for jumping in. All right, Mr. Strong,
Yes.
I have to advise you that this could be considered a violation of the probation if you're still on it. You understand that?
Yes.
And
I
if it
sent off
is,
I sent
I'm
off a
sorry?
writ. Yeah, I got a probation violation. I had sent off a writ. I got a hold in here for the same case. I sent off a writ. I'm waiting on them to respond. They responded once, but I didn't send my proof of incarceration. I just resent my proof of incarceration with another writ out a couple of days ago. So I'm waiting on them to respond while I'm in here. I might go to court for them in here too. It's Allen Park and Melvin. They're the 24th District Court. I've been on probation since 2017 with the same case.
Now the hearing takes a sharp turn. What initially looked like a straightforward retail fraud case suddenly opens the door to a much bigger problem, ongoing probation issues stretching back years. And when Strong casually mentions he's been on probation since 2017, you can almost feel the courtroom pause mentally for a second, because that immediately tells the judge this defendant has a long legal history still actively hanging over him. What makes this section so chaotic is how many jurisdictions and holds start getting mentioned all at once. Wayne County, Harper Woods, Allen Park, probation violations, incarceration paperwork, pending responses. It becomes a tangled web incredibly fast. And honestly, this is where a lot of defendants lose track of what case is even affecting them anymore. One unresolved issue creates another hold, another hearing, another violation risk. Judge Simpson actually handles this carefully. He doesn't explode. He doesn't lecture. He keeps narrowing the focus back to one key point. Do you understand this plea could violate your probation? That's the legal landmine here. Because even if this current sentence ends up relatively light, another court can still punish him separately for violating probation terms.
That is correct as to the Wayne County hold, Your Honor.
Okay. So,
I got another Wayne County hold. This for Harper Woods, but them my last two holds. I got a retail fraud, or is it shoplifting? I think it's a shoplifting out of Harper Woods. It happened. I believe it happened earlier this year. It happened earlier this year in February.
Mr. Strong?
Yo,
okay, so now that we've determined that you're on probation, sir, I have to advise you that your plea in this case could be a violation of that probation. You understand that?
yes,
Okay. And as such, that other court could sentence you to the maximum allowable under that other charge or charges. You understand that?
yes,
And understanding that, you still wish to plead no contest?
yes.
Okay. Has anybody promised you anything other than what's been stated here today to get you to plea?
I'm not sure. I can't remember. I think I'm supposed to be getting tried concurrent. I'm not sure.
Mr. Strong, the judge is asking you if anyone promised you anything outside of what we've said today in court to get you to plead no contest to this charge.
I can't remember specifically. I think you said something about a concurrent plea or deal they was thinking about doing with my time served.
So, Mr. Strong, did anyone promise you anything outside of what's been stated today on the record that you would be pleading no contest to 93-day misdemeanor? Did anyone promise you anything outside of that to get you to plead to this charge?
No, I don't think so. No.
This exchange is way more uncomfortable than it first appears, and you can tell the courtroom is struggling to pin Strong down to a clean answer. The judge is asking a very basic plea question. Did anyone promise you anything outside the agreement? Normally, defendants answer instantly, yes or no, simple. But Strong keeps drifting into uncertainty, talking about concurrent time, credits served, possible deals, and things he thinks somebody mentioned earlier. That becomes dangerous territory legally because plea agreements must be crystal clear. If a defendant later claims, I thought I was promised something else, it can create appeals, motions, or attempts to withdraw the plea entirely. That's exactly why Judge Simpson and defense counsel keep rephrasing the question over and over until they finally get a direct answer on the record. And honestly, you can see two different courtroom worlds colliding here. The court is operating with strict procedural language, while Strong sounds like somebody trying to mentally piece together multiple jail conversations, probation issues, and expectations all at once. He seems genuinely unsure what counts as an official promise versus informal discussion.
So nobody promised you anything else?
Not other than what I stated.
And what was that?
I believe.
So nobody promised you anything in regard to this case other than that the charge would be reduced. Is that correct?
And ran concurrent with my time
Concurrent
here.
to what? To what's your time now?
6 months. I'm in here for 6 months. I get out on February 22nd.
I believe Mr. Strong might be referring to the fact that he would have 93 days credit at the time of sentencing
Shocked.
in this charge.
Shocked I am.
So I think he is.
Okay, so that's what he's referring to.
I believe so.
Ah, okay.
I apologize.
Anything
about the
else,
misunderstanding.
Okay. Anything else, Mr. Strong?
No, Your Honor, Cedric Simpson.
Okay. Has anybody threatened you or coerced you in any way to get you to plead? Oh boy.
No,
No? Okay. You're doing this voluntarily and of your own free will?
yes, I am.
Okay. The court has been provided and has reviewed Pittsfield Township Department of Public Safety report for their case number 2022-8001. Any objection to the court having reviewed that report?
No, Your Honor.
Pittsfield.
Based upon the review of that report, the court does find that there's a sufficient factual basis in which the court could determine the defendant guilty of this offense. Counsel, have I complied with the court?
People are satisfied.
Yes, Your Honor.
The court will accept the defendant's plea of no contest to count two. Count two. Count one is dismissed. So we don't go through this again. Is there any restitution?
To my understanding, sorry, Your Honor.
Go ahead.
To my understanding, there was no restitution
I know.
issue.
I don't see an issue that there's restitution in this when I read the report. Okay. Any objection to proceeding sentencing from either side?
None from the people.
No, Your Honor.
Thank you. Sir, is there anything you want to say before I impose sentence?
And here comes the part judges pay very close attention to, the allocution. This is the defendant's opportunity to speak directly before sentencing, and sometimes these moments can genuinely influence how a court views accountability, remorse, and future risk. Strong immediately shifts into apology mode, mentioning Pittsfield Township, Eastern Michigan University, jobs he couldn't keep, and how he wasn't trying to seriously hurt businesses. But the deeper story here is instability. Listen carefully to what he's describing. Multiple jobs, inability to stay consistent, repeated retail fraud cases, probation stretching for years, bouncing between courts. This doesn't sound like somebody with structure in his life. It sounds like someone constantly trying and failing to regain control. At the same time, there's also a noticeable contradiction woven into his statement. He says he wasn't trying to harm businesses, yet this is clearly not an isolated incident anymore. The court already knows about other retail fraud issues and probation complications, so the apology lands somewhere in between, sincere and frustrating. You can hear somebody trying to explain himself, but you can also hear a pattern the system has probably heard before.
Yes, I would like to apologize to the citizens of Pittsfield Township and to the county, Washington County. I stayed out there for 3 years. I went to Eastern Michigan University. I enjoyed it. I had the time of my life. I was just stealing food to get by. Both times. I went to court last week for a charge I caught back in 2018 with 1482 District Court. And court in Ypsilanti for a charge retail for a third degree for stealing food out there at Eastern Michigan University. I didn't have a job. I didn't have a meal plan. I had a bunch of jobs, but I couldn't keep them. I had about 15 jobs my last year in college. In and out, in and out. I'm my own first-time non-violent, non-felon offender. I wasn't trying to cause too much harm, make a business go bankrupt or anything like that. It's that the Myers Strong nowadays put a lot of stock into it. My side bought a lot of stock on Cash App, but I apologize.
All right. Thank you. It's the sentence of the court, $125 state minimums, 93 days jail, credit 93 served. Thank you, Mr. Strong. You have a happy holiday, sir.
Hey, how do I pay? How do I pay the 125?
Mr. Strong, we can be in touch. I'll be in touch with you, okay? I'll send you a letter.
All right, thank you.
God bless you.
Thank you, Your Honor.
Thank you, sir.
Thank you. Okay, I'm going to leave, come back and start again.
What an ending to this hearing. After all the confusion, overlapping probation problems, and uncertainty about promises and sentencing, the final outcome actually lands relatively softly compared to where this could have gone. Judge Simpson imposes 93 days with credit for 93 already served, meaning Strong effectively walks away having completed the jail portion immediately. On paper, that's a significant break for someone carrying multiple legal complications. But don't mistake a lighter sentence for a clean slate. The judge repeatedly warned him that this plea could still trigger probation consequences in other courts. That danger never disappeared. So while this hearing closes calmly, the larger legal situation surrounding Strong may still be far from over. And honestly, the most human moment might be the very end. After all the legal terminology and procedural chaos, Strong suddenly asks a simple question: how do I pay the 125? That's the reality of lower-level criminal cases in America. Fines, probation, court costs, holds, transportation orders, It all becomes this giant web that follows people long after the headline moment ends. Judge Simpson stayed patient throughout, even when the hearing drifted repeatedly off course. He kept bringing the focus back to clarity, procedure, and making sure the plea stayed legally valid. In the end, the court accepted the no contest plea, dismissed count 1, and finalized sentencing without escalation. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.